And I want to welcome you to another episode of Beyond the Surface Radio. I'm your host, Dr. Wanda J. Evans-Brewer. And this afternoon, I have the pleasure of talking to an attorney from downtown from Gottreich and Grace. His name is Tim Grace. And you pretty much do criminal law. Is that true or no?
Good afternoon, Dr. Wanda.
Hey, good afternoon.
Thanks for having me here. Yes, we do. Majority of our practice is in criminal law.
Okay, do you do anything else besides criminal law?
We do a little bit of employer issues and a little bit of that stuff too.
Okay, just want to make sure that everything, as the viewers listen, that they know when they contact your office, because I'll give them all your information at the end, and they'll know exactly what they should be contacting you for.
Great.
So anyway, I'm excited that you decided to sit down and talk with me. I gave you a couple of speaking points. I don't know which one you want to start with, whether you want to start with Fourth Amendment or you want to start with the changes with the medicinal marijuana laws.
Why don't we go with the marijuana stuff first, because that's real interesting.
Okay. I was excited about it. I saw that there was a specific case that actually it just seemed like it should have been, a slam dunk for the gentleman, where he pretty much filed a lawsuit against Miller Coors because they released him from employment, not because he did anything wrong, but just simply because he tested positive. Right. And I wanted you to talk to the viewers who are, a lot of people are under the impression because there is a medicinal marijuana law, they're looking at all the changes throughout the various states, and particularly Colorado, and they think that means that actually, it can be a far more lax environment. What's happening on your end, or what do you foresee happening on your end in terms of this law?
Right. I think what the first and most interesting thing we should talk about is why should the federal government be allowed to regulate and ban marijuana use at all, even if the states enact medical or recreational medical marijuana laws? So the federal government has clearly called marijuana a Schedule I banned substance and something you can be arrested for or prosecuted for and go to jail. But many of the states, as you've indicated, have not only passed the medical marijuana laws, but have also passed the recreational laws to actually be able to use marijuana, and that seems to be in direct contrast with the federal law. So
Illinois hasn't added the recreational piece, has it?
No, Illinois has not. Illinois now has the medical marijuana, which I believe goes into effect in this year. I'm not exactly sure when, but it's going to be soon. They've got a whole mechanism set up for people to get doctors' prescription for it to allow them to have the medical marijuana. Okay. So, well, the first issue is the federal government can regulate it based upon the Commerce Clause in the United States Constitution. So anything that can affect interstate commerce allows the federal government to establish laws. That's where we saw how the federal government, to its good, got involved with a lot of the civil rights stuff back in the 60s and 50s with the trains going from point A to point B. It affected interstate commerce. Well, that's how they get the right to do that, because a lot of times you say, well, why should the people in Washington be telling the people in Illinois what they should and shouldn't be doing? Well, that's how they do it. So the issue came pretty much to a head in 2005 when California enacted their medical marijuana laws, and the federal government was prosecuting people who were engaging in conduct that in the state laws in California were legal, but the federal laws were not legal. So what happened was it was a case in 2005. It was United States Supreme Court of Gonzalez versus Reich, and R-A-I-C-H. And what it did was the Supreme Court said that the feds are supreme, that they can ban local cultivation and use of marijuana despite the fact that the states allow it. So where does that leave us? It leaves us in a strange world, because what it leaves us in is that, and if you got any questions, Dr. Wanda, you just jump right in, okay?
I will.
It leaves us in a strange world where people are engaging in conduct, either medical marijuana use or recreational marijuana use, that is legal in a state like Colorado, but it's illegal in the federal jurisdiction.
Why does the government do that? Why are they so fickle?
Well, it's interesting. That's a good word for it, because it appears that the new wave of which I would think is more of an enlightened approach, is that marijuana should not be classified as heroin or rock cocaine or methamphetamines or anything like that. And the states have recognized that. In the current administration, the current Department of Justice has also recognized that, and they're simply not prosecuting the small amount of marijuana, small-time users. The dealers they're still going after, but the small users, they're not. This administration and this Justice Department is not prosecuting them. That's great if your position is that we should have the use of this drug, which a lot of people, which probably isn't from my expertise, but say is no worse than having a glass of wine. But
yeah, well, the president said that is no worse than alcohol as well.
That's right. That's exactly what President Obama has said. The problem is if there was a change in the government's approach, which we all know what I mean by that, a new administration, then the new administration could go forth and begin to prosecute these marijuana cases. So
okay.
No one knows what's going to happen.
But what's the goal with prosecuting? Because a lot of people see this as sort of a harmless addiction, a harmless vice. You know, what is the? I mean, I just don't know mass murderers that got hyped off of marijuana. What is it that makes this? Is it just simply that it's a drug?
That's a good question, and I agree with you. I don't know the answer. I don't know the answer as to why we have taken marijuana and classified it in the same way we would classify heroin. The marijuana classification happened, close to 100 years ago. They're going based upon those classifications, and they've never changed that approach. And I think what's going to happen is as more and more of the states begin to allow the use of both medical and recreational marijuana, that the feds are going to have to take a new look at this. And it's all about the political part of it. I don't know the answer to where this is going to head out. I just think that rationally speaking, that they'll do that.
Well, I know that a lot of the cases that have come into criminal court there are tons of cases that just eat up time that's grounded in marijuana use, transportation, selling. How often do you see this?
Every day. Every day. It's one of the biggest. I tell you where we see it the most is it's the biggest, and we'll talk more about this when we talk about our Fourth Amendment issues. It's the linchpin or the triggering probable cause to continue a search on a vehicle when the officer smells marijuana. That allows the next step. The intrusion. But yes, it's every day. The state of Illinois every day is prosecuting people for marijuana. The city of Chicago passed a law, an ordinance that said they were going to make small amounts to be only something that would be a ticketable offense. But it appears that the police department has not given out a lot of those tickets and continues to prosecute them as Class A misdemeanors, which could give you up to a year in the Cook County Jail.
Which is, okay, so isn't there a benefit to simply writing the ticket? I mean, we have become a bit of a, fine, like everything has a fine attached to it. We really put a financial attachment on everything. So why not take the money and run? Because what I'm reading is people are saying, no matter what, folks are going to smoke marijuana, and it's cost all kinds of socioeconomic backgrounds. It's men, it's women, like it's not the flower children anymore.
Yeah. And the other thing is if you get a beat car with two police officers, instead of them just writing a ticket and off the guy goes, the person that was got the ticket, you tie up two police officers that would be better served, maybe checking to see keeping the neighborhood safe. So it's a manpower issue too, because you take two guys off the street for a couple hours to process a person who has been arrested for, 2 grams of marijuana. Yeah, I agree with you.
What happens if you have the car and you're pulled over, but an officer smells the marijuana? Are you still set for the same punishment? How does the car protect or not protect? I guess that's my question.
It doesn't. It's and now we're moving kind of to the Fourth Amendment issue. So which I don't have a problem thresholding over to. So in the arena of the Fourth Amendment law, it goes like this: an encounter between a police officer and a citizen should be very minimal. If I am driving a car and I am speeding, okay, and a police officer stops me, he has probable cause to detain me for the purpose of writing that ticket, no doubt. He approaches the vehicle, okay, and he asks me for my license and insurance, and I give that to him. He doesn't see anything else that would require him to extend our encounter. He should write me the ticket, and off I should go, and I'll see him in court. But if the police officer were to approach the vehicle, for instance, and see a bloody knife sitting next to me, a handgun sitting next to me, or was to smell marijuana, that would be enough reasonable, articulable suspicion, meaning facts he can point to, that can allow him to then possibly search my vehicle.
Okay.
And then what happens in these cases is when they search the vehicle in the trunk, they find something that's much worse than
extra.
Right, the gun, the bloody knife, something else, and that allows the officer to get into my stuff right there. So to the average person, when you're pulled over by the police, you should know your rights, and your rights are they have a right to get your license, to confirm you have a license. They have a right to make sure your vehicle's insured.
Okay.
Now, if you don't have a license, your license is suspended, which I see happen a lot of times, then you're under arrest. And then they can arrest you and charge you with driving without a license. Then if the municipality has a procedure whereby they tow the vehicles, they can tow the vehicle. And then they're allowed to do what's called an inventory search of the vehicle. And when they do the inventory of the search of the vehicle, they're able to then locate any contraband or anything along those lines.
And I understand that they do an inventory search of the vehicle, and lots of them want to understand what that is, because there is actually some rules to an inventory search, is there not?
Correct.
Okay. Can you explain to them what does an inventory search do or not do?
Well,
what should it do?
The inventory search is going to be based upon the procedures that are set out by the city or village or whatever the local municipality is. The theory behind the inventory search is if I've got a gold necklace in the vehicle, it protects both me and the officer. Because if they just said, Tim, you're pulled over, we're going to call a tow truck, they're going to tow you to the tow yard, and then I post my bond for my driving without a license, and I go to the tow yard and I say, hey, where's my gold necklace? And they say, there was no gold necklace in here. What are you talking about? Then I go to the police and I say, hey, where's my gold necklace? And they say, no gold necklace in here. We don't know what you're talking about. So the inventory search in theory is supposed to be something that protects either an accusation against the police officer of stealing or to protect me from someone taking my stuff. Now, where has that exploded to? That has exploded to every single arrest turns into them taking the car apart under the theory that they're doing an inventory search.
Okay.
And the state of the law right now is that if the vehicle could be subject to a civil forfeiture, then the car is okay to be completely searched. And if it's subject to a tow, it can be completely searched. There's not a lot of help for people, and I fight this fight every day, of the search incident to arrest, the inventory search of a vehicle. The language some of the local municipalities use for the inventory search allows them to do pretty much whatever they want once they have you on a valid arrest.
Yeah, but I guess one of my concerns with the inventory search is that it was supposed to be sort of administrative.
Right.
What you're describing is not administrative completely, but it's becoming investigative and used to criminalize.
Yep.
So if the courts have already given a structure and said don't do that, how can a citizen protect themselves and say, hey, look, this was not, they weren't itemizing anything, but in fact they went looking for stuff.
Right. I have been able to find very little relief on the inventory search of the vehicle.
Okay.
I've been very difficult to get any way around the fourth. Well, I guess the courts don't call it a Fourth Amendment violation, but it certainly is a search within the meaning of a search. And right now, the state of the law is, if it's going to be towed, then it can be inventoried. And if it can be inventoried, I mean, they can go into trap doors. They've been known to take apart dashboards. They've been known to do all kinds of stuff.
Yeah, but it shouldn't happen at location. Shouldn't this be an actual site that the vehicle is towed to, and where and with some sort of document that represents a search?
There is, but the problem is they're I can only give you their argument because I agree with your sentiments. Their argument would be, once we release the vehicle to the local private tow truck, anything can happen to it. So we believe we're protecting you right now, by doing that inventory search.
Oh, okay. So that's a little bit of slick language.
Sure is, isn't it?
We're going to look at it real fast just in case.
Yep.
That's
what it is. Now, we're a success on a lot of these cases as far as how you protect your privacy of what's inside your car is if you're pulled over and you have your license, you have your insurance, and you do not have any other indicia or facts that would prolong the stop, which would allow a search, is to provide that information and, to know your rights. And your rights are that you don't have to consent to a search. When a police officer comes up to your vehicle and he says to you, you blew this stop sign, you've got valid license, you've got valid insurance, hey, by the way, can I search your vehicle? If you say yes, you forfeit your Fourth Amendment rights, and then they can search the vehicle.
Okay, now haven't there been cases where individuals have said yes, basically, for intimidation factors, not knowing their rights, and have come back and said, hey, actually, I was sort of, pressured. I was coerced into saying yes, but actually I didn't mean that. What has become of those kind of cases?
Yeah, there's a whole line of cases on that. It's all under the show of authority. If a police officer pulls me over for that stop sign, and I provide my license and insurance, and he say he's by himself, say he has not asked me to exit the vehicle. If he says, hey, do you mind if I search the car? And I feel under no pressure to do that, say, yes, you can search my car, then they find a weapon, for instance, that search would probably be upheld as valid consent. Now, if the same situation happens and they box me in, there's 4 police officers, 2 of them have their gun out, they are walking around the car, they're yelling at me, they tell me to put my hands on the wheel, they rip me out of the car, that right there, that show of authority probably makes my consent to be tainted, meaning it was not given freely and voluntarily, and you could probably suppress a stop like that where you would be under the position that, they violated his rights because they coerced the consent out of him. So it's the show of authority, it's all the factors that go into the encounter, yeah.
Okay. So, it sounds like with Fourth Amendment, what people need to understand is that first you need to be in the right in the first place to really survive that process, that you actually need to be legit.
Right.
License, registration, preferably a clean vehicle that you're not actually harboring any contraband of any sort, whether it's a weapon or a drug. And then you tend to fare well, even if you've been profiled. How many of these cases are just simply profiling cases?
Well, I think that what happens is you're talking to a former prosecutor here, so a lot of times these police officers justify their bad acts with the thought that they're getting a gun off the street. So a lot of times the police officers are working on what's called a hunch. And you got to give it to the cops. Sometimes they know the good guys from the bad guys, and they'll pull someone over on a hunch. Now, sometimes there is profiling, and profiling is a fact of life in our society, anywhere from when you go to Jewel to get milk to when you're driving in a neighborhood that is predominantly African American or Hispanic and late at night and all the things that go along with that, where the police just say, pull them over. And sometimes the police will contrive didn't have his directional, had a tail light out, was weaving, all of these things to get themselves in the position where they can pull the guy out of the car and search the car. Then they later claim that the evidence was in plain view, which is why they were able to pull the guy out.
With so many variables in place, how do you practice law? This is a lot of variables.
Well, you're right. It is a lot of variables. I will say this, that I don't think that the average police officer is out to violate someone's rights, and I don't believe that they wake up in the morning and they say, I'm going to go violate someone's rights. I don't think that they do that. I think there is a small percentage of the officers out there that don't care about your rights and think that the end justifies the means. They know this person is a bad guy in their minds, so they're going to violate their rights. And I think that's what happens. So how do I practice law on this? I try to show through a hearing a motion to suppress the evidence recovered based upon a violation of the person's rights, that the story that the police officer came up with just doesn't make any sense.
Okay.
And camera technology that we've had come upon us in the last 5 to 8 years has been a really great help.
Yeah, it works both ends, doesn't it?
You're right. There have been situations where the cameras, don't work for us. But I think what it does, though, is certainly has helped keep the police officers at bay who are inclined to maybe stretch the Fourth Amendment issues. But again, I will say again, I have found that most of the police officers I have encountered have not been out there to violate people's rights. I mean, their goal
I'm a pretty optimistic person in that area in general. I come from Detroit, so I'm used to back when I was living there was less racial divide in that piece, which is very, very strong in Illinois and particularly in Chicago. So I'm used to, basically predominantly black police force. So that's not really a card you necessarily could pull. So, it had to do with an individual's integrity, what was their heart's content as opposed to just, de facto, this is what I do.
Right. No, that's a good point. That is a good point. But to your greater point, it happens. There's no doubt it happens.
Okay.
No doubt it happens.
So what do you foresee? I mean, we have a law that, a medicinal marijuana law that took effect January 1st. We have folks, I'm sure, lined up to see their doctors, but there's a list of like 42 ailments that fall under the umbrella of okay to at least be considered, diabetes, glaucoma, rheumatoid arthritis, HIV, cancer. So what do you foresee happening in the courtrooms for you?
Well, let's talk about that Miller decision, because that's a really that Curry versus Miller Coors, and you hit the facts right. Mr. Curry was employed at the Coors Brewery. He did suffer he had like arthritic pain and hepatitis, and he had a valid medical marijuana card in Colorado. They gave it to him to alleviate his pain. And more importantly, which I think is interesting about this case, is there was never any allegations that he was under the influence at work or that his work was compromised in any way while
he followed all the rules.
Right, he followed all the rules.
Mm-hmm.
There was a question as to whether or not he disclosed his marijuana, his medical marijuana card, but I don't think that is what turned the case against him. So he filed the lawsuit, and he had three essential theories. The first one was that they discriminated against him because of his disability. He claimed, and I think he was correct, that his ailments were a disability, and under the federal disability law, you cannot discriminate against him. Well, the court said no. They said the employer may have a written drug policy, and they may terminate someone if he tests positive during working hours. And this is where marijuana is different than alcohol or
wine. In the system.
Right, it stays in the system.
Yeah, it stays there.
And the court said that because the Coors applied the policy equally, meaning those with medical marijuana cards were discharged, and those using it recreationally were discharged, that they could terminate him. So if the policy is applied equally, not just against medical marijuana users, then under a claim, a theory of disability discrimination, a plaintiff would lose. Mr. Curry lost on that one.
But they ended up winning unemployment.
No, that's different. The unemployment was different. That's under getting unemployment compensation.
I understand, but what bothers me about him losing and winning is that, still the taxpayer is paying, like somebody's paying.
Oh yeah. Yep. He also tried it under an invasion of privacy issue, and the court held that the forced disclosure did not constitute an unreasonable manner of intrusion or intrusion for an unwarranted purpose. That's what they said. They said that it wasn't unreasonable to force your employees to articulate whether or not they have marijuana use.
Well, I think that's fair.
And the last one, which I thought was the one that gets us back to what we initially started talking about, was the lawful activities. So there are laws out there, federal and state, that said an employer cannot discriminate against somebody who engages in otherwise lawful activities off the premises, not during working hours. So so let's give something that would be something Coors could not do. Let's suppose that I am a dancer, okay? If I'm not doing it on working hours and I'm not doing it on the worker's premises, a person who is like a dancer would have a legitimate claim if Coors fired them because, you know what, we don't like that you dance during your off hours.
Okay.
But this is where we get back to the original conversation. Marijuana is not lawful in the federal law, so Mr. Curry could not take advantage of engaging in lawful activities because it's not a lawful activity. It may be lawful under Colorado state law, but it's not lawful under federal law. So we're right back to where we began.
Yeah, but it makes me frustrated because, I expect the Supreme Court to be just that, supreme. And I understand that each state has its own, Supreme Court, its miniature version of it. But why have that conflict? Like that, so where am I protected? Like, would he have been better suited to stay in Colorado?
I don't think
he followed all the rules. He had his car. He wasn't on the premises. They wasn't upset with him about his employment, his work ethic.
Right. The problem is that you have this pressure or these two rights leaning against each other. You have the federal law that does not allow marijuana, and you have the state laws that do. And under the supremacy clause, the federal government will reign supreme over the state government. And until Congress acts, until Congress says, hey, we're going to allow marijuana to be used medically or recreationally, then the Supreme Court's job is merely to interpret the laws of Congress as long as those laws don't violate the federal Constitution.
Okay, listeners, I hope you taking this in, that actually you need to approach your congressman, your representatives, and decide where you're at on what side of the fence you are, and get them to represent you. Because this just seems it's so ugly that I actually could have a legitimate illness.
Yep.
Be on my last days, but still want to be a productive human being. And I had a guest speaker a couple of weeks ago, and she spoke about human resources and how Illinois is an at-will state.
Yep.
So, at will, they could just let you go.
Right.
So, part of it was, they had the right to let them go anyway. But, it's discouraging to know that you can actually follow the rules, do what you've been asked to do, not, overdo it. Because most of the marijuana cases, I'm sure, that comes in the courtroom, folks are overdoing it. You don't have to be in your car smoking.
Right.
You really don't. You don't have to, walk into, the court building smelling like cannabis. You don't have to do that. They do a lot of over-the-top stuff. He was pretty much a gentleman and decent about it, and he lost.
Yep. And there is I think that if the federal government would get their act together and would legalize, or at least leave it up to the states. Get rid of the federal marijuana laws. Maybe if someone's importing 5,000 pounds, the federal government could get involved. But leave it up to the individual states. Let them be the experiment in democracy. And if Colorado wants to have marijuana, recreational or otherwise, then let Colorado do that. But if the folks in Wisconsin say, you know what, we don't want marijuana. We believe that marijuana is dangerous. We believe it's a gateway drug. We believe in all that stuff. Then the folks in Wisconsin can say we don't want marijuana, and they can pass their laws. And if you live in Wisconsin and you don't like those laws, then you should move to Colorado, unless you can get your state representatives in Wisconsin to change the laws. So I think that's what should happen. I think the Fed should take a step back and let the states decide who wants marijuana and who doesn't. That would leave a guy like Mr. Curry in a position where he would at least be able to follow the law and not pick and choose, because he's being forced to pick and choose which law to follow.
Okay, so this might mean he would have to, once again relocate.
Yeah.
Yeah, and I mean, I guess that's not a bad choice. If I were, extremely ill and it was the only thing alleviating it, then what's the difference? I do want the listeners to know that this particular law, even though the law has changed, is called the Marijuana Policy Project. That in fact it is not necessarily a permanent state of being. That they're giving us 4 years to see what it does and what it doesn't do and how the state responds to it. So there's a big opportunity to have a voice in it.
Yeah.
I'm neither a proponent or against it. I mean, I feel like pharmaceutical companies have wrecked shop on us. Sometimes I listen to the, when they give you the what you call that, as the commercial is wrapping up.
Oh, all the do's and don'ts of the
and I'm listening to it, and particularly there was this one pill that was supposed to help a man's libido, but the woman could not hold it. They, specifically said, the female couldn't hold it. If she held it, apparently it could be absorbed in the skin. And it described all the stuff that would happen to the woman. I said, oh, my God, look at what they put on the market. So I'm actually, and then I started trying to understand, like, if I can't hold it, if this guy uses it, what happens if, I internalize what he's taking in? So I already know the pharmaceutical companies from FinFin, from all kinds of stuff, have had a good time with us. So in that sense, I'm less scared of marijuana than anything. I know there's some tricky stuff that they do in terms of dipping it. I do remember a news special where they made it clear that if it's Kush, that it was equivalent to crack cocaine, and that the sentencing for that was on that level. Can you explain the difference and what happens if it's been dipped in embalming fluid, if it's regular marijuana? What are you seeing as we wrap up this discussion?
Yeah, so what's happening is the marijuana cigarettes will be tested by the Illinois State Police Crime Lab or the Chicago Police Crime Lab, depending where you are. And what you think is a marijuana cigarette, organic, common marijuana, is actually been dipped in LSD, has been somehow been made more stronger, and in fact it comes back not as marijuana but as another Schedule I controlled substance. So yeah, that's you make a great point about the marijuana. The marijuana has certainly gotten stronger over the years of, like you said, the flower children it's a lot more potent, and some of the things that we claim are marijuana may not really even be considered biologically marijuana. It's something much stronger.
Mm-hmm.
And that's the fear.
That's gotten us in trouble, hasn't it?
Yeah, that's troublesome. That really is. That really is. And that's why regulating it would be so much better if you had, not that I want to give too much power to the pharmaceutical companies, but at least if it was regulated by the FDA as a drug, then, when I buy a Coca-Cola, it is Coca-Cola. It's not something different. And if the Coca-Cola doesn't put into it what it says is in it, I at least have recourse in the courts. You go out and buy marijuana on the street, and you don't know what you're going to get.
Okay, last question. And you sort of segued to it with this discussion. That there was a big discussion about the synthetic marijuana that's at the gas station.
Right.
And that was, like folks, especially young people coming out of the high schools and things like that, really, really migrated to that. It's extra cheap, but it's also extra addictive. what's the penalties for being caught with that?
I believe that is just those are the ones that are sold over the counter at the gas station.
Yeah.
Yeah, those are, I believe they're, as long as you're over the age of 18, it can be sold. Those are regulated by the FDA.
Oh, so it is regulated.
I believe so, yes. Yes, I believe so.
So even though it causes all kinds of havoc on the body and encourages all kinds of erratic behavior, you can kind of get away with that. I mean, there's nothing, there's no life in it. It really is sort of XXX. Yep. It's like the equivalent of being a huffer on some respect.
Yep. No.
Wow.
Yes. Scary stuff, huh?
Yeah. So I can get away with that, but I can't get away with
right.
standard marijuana necessarily. Well, we've been talking to Tim Grace again of Gottreich and Grace, attorneys at law. If you need a good attorney, you should consider contacting him. Their office is located at 200 West Superior Street, Suite 210. That is Chicago, Illinois, because I know I do have some listeners that are Michiganders and Californians and the like. Zip code is 60654. And what's a good number?
My cell phone's always on. 773-343-7657. And
again, I hope that we sit down and talk again. It's a lot that goes on with litigation that the average person doesn't understand. They kind of there's a real peer society out here, I've discovered, that you talk with people and just like a whole team of people stand around and give each other all kinds of bad advice that they consider legal advice, except they've never talked to a lawyer, which was why I was excited to talk to you. So, again, I thank you so much, Attorney Grace.
No problem. Thank you. It's very enjoyable discussing these issues with you.
Good. And until we chat again, be safe in God's grace.
You too. Thank you. Bye, Doctor.
Bye.
Bye.